Hello everyone, I am Rusha Mukherjee, a student of FOUNDER Law College and presently interning with LEXIS and Company. Today I am going to talk about the Ayodha dispute. We often wonder that why is the Ayodha dispute so complicated and why do we have to understand so many aspects for it. The reason lies that the Ayodha dispute actually started 500 years before. Now the title of the land, from when should it be calculated? From 1528 when the Babri Masjid was constructed, or from 1949 when the Ram idol was placed, or from 1992 when the Babri Masjid was demolished. Now the Allahabad High Court was not able to resolve the conflict. It was the second longest case before the Supreme Court, that was also 40 days. Here there was many problems. The order of the High Court failed, the mediation failed, everything failed here. It was a result of the Hindu-Muslim conflict. In 1528, Babri Masjid was built as a tribute to Babur, but it was stated that it was done by demolishing one of the Ram Mandirs. And due to this fact, in 1853 to 59, there was certain fights between the Hindu and the Muslims. To stop it, the British interfered, stepped into it, and then they told that the inner part will be under the Muslim control and the outer part will be under the Hindu control. And for that purpose, did fencing of that part. In 1885, the first court case took place. The Mahant Raghuveer Das actually wanted to worship and for that purpose make certain constructions. There was repeatedly certain cases that was in file after that, like the Mahant Ramchandra filed a case for worship. In 1959, Nirmohi Akhara wanted possession, and we know that in 1961 the Sunni Waqf board also wanted the same. Meanwhile, in 1949 the Ram idol was placed, and that too when nobody was around, which was not a very legal act. This created these cases, that is the 1950, 59 and 61 cases. On the other side, the Vishwa Hindu Parishad, that was the Ram Mandir committee, was set up by them. In 1986 came the first verdict of the court of Faridabad, where it was told that they gave the entire worshipping right to the Hindus. This enriched the Muslims. What they wanted? They wanted to create the Babri Masjid Action Committee. Now in 1989, Ram Valla Priyajman wanted possession. In 1990, there was an incident where Ramakrishna Advani had started a rath from the Somnath of Gujarat to Ayodha. And what happened there was, due to a lot of havoc, he had to get arrested in Bihar. And this was very dramatic incident because he was a senior BJP leader. And after this incident, they took their support, they withdrew the support from the VP Singh government. In 1991, the UP government stepped in and took over the disputed area. In 1992, there was the historic event of the demolition of the Babri Masjid. Now the Liberhan committee was made to know and understand how was this made. When a case was filed before the Allahabad High Court to settle this dispute, they wanted the archaeological survey to actually step in and make a report of it. There it was said that in 12th century there was a mandir and in 15th century the masjid was built. But the time in between could not be decided. So the Allahabad High Court wanted to divide the land into 3 parts and then wanted to give the Ram Murti part to Ram Lalla Vibhajan, the Ram Chabuta, Sita Rasui and Bhandari to Nirmohi Akhara, and the Sunni Waqf board would get the remaining part. Now, in 2011, the Supreme Court put a halt into it and said that whatever was being told by the Allahabad High Court was something not substantial, unsubstantial. Why? Because it was not sought by the parties. After a lot of things like the Subramanian Swamy filed the case before the Supreme Court in 2016, but then out of court settlement was proposed, but ultimately in 2019 the court proceedings started. They wanted a mediation report and also the molding of relief. What is molding of relief? That is the things, all the relief sought have to be altered. Now the Nirmohi Akhada, the Sundar Waqf Board and Ramlala Vibhajan was headed by Mr. Jain, Rajiv Dharan and C.S. Vaidyanathan respectively. One of them wanted the inner possession, that is the Nirmohi Akhada. The Sunni Waqf Board wanted the inner possession and the courtyard part. And they told that actually the Ram Chabuta was the birthplace of Rama, and they did not have any objection if Ram was worshipped there. And Ramlala Vibhajan said that from the very beginning the Ram temple has existed there, and since 1949 the idol was also there, so they had a right, and the Muslims never had an exclusive right to all the properties. Now the court said that nothing can be decided just on views, beliefs, traditions, etc. It has to be based on legal principles. And taking all the views together, they said that the Article 142 has to be invoked in this case, and the Babri Masjid's area, that is the 2.77 acres of land, will be given to the Ramlala Vibhajan, and the Sunni Waqf Board will get 5 acres from the government, maybe central or the state. All the decisions that has been made by the Supreme Court was obviously not able to satisfy each and everyone, because we know that none of the cases verdict pleases everybody. But it would be better if we understand it in terms of the unity and integrity of the nation, and not according to our own religious point of view. I hope you like this video and put your own views in the comment box. That's all for today. Bye.